If you're living in the UK on a graduate visa, or you're planning to move to the UK with your family, then this update is something you shouldn't ignore. On 9 July 2026, the Home Office published a new statement of changes called HC 259, introducing several updates to the UK's immigration rules. But here's the good news. One of these changes finally fixes an issue that has been affecting some graduate visa holders and their UK-born children. In today's video, I'll explain exactly what has changed, who is affected, and what it could mean for you. Let's get started. If you are interested in UK immigration, visas, sponsor licenses, and official Home Office updates, make sure you're subscribed because I only explain information based on trusted sources. Now, let's look at what has changed. On 9 July 2026, the Home Office laid HC 259 before Parliament. According to the document, these changes will come into effect on 30 July and 3 August 2026. The amendments cover several immigration routes, including graduate route, family migration, asylum procedures, EU settlement scheme, suitability requirements, and several other immigration categories. However, the document also makes one thing very clear. Most of these amendments are not brand new immigration policies. Instead, many of them are designed to make the existing immigration rules more consistent, remove drafting issues, and clarify how the rules should be applied. Let's start with the biggest update, graduate route update. The most important change in this statement affects a small group of graduate visa holders. Before this amendment, if someone switched from a student visa to a graduate visa and then had a baby in the UK, there wasn't a clear immigration rules pathway for that child to obtain immigration permission. This created uncertainty for some families. The Home Office has now closed that gap. From 3 August 2026, a child born in the UK during a parent's current graduate permission can apply as a dependent under the graduate route. Normally, the child's permission will expire on the same date as the parent's graduate visa. Now, it's important to understand what this change does not do. It does not allow new overseas dependents, it does not create a settlement route, and it does not expand the graduate route generally. It simply provides a clear immigration route for UK-born children in this specific situation. For the families affected, this removes a lot of uncertainty and creates a straightforward process under the immigration rules. The statement also introduces several amendments to family migration. Again, these are mainly designed to make different immigration routes more consistent. One important change relates to partners of people who have temporary protection permission. Previously, there were situations where a partner's permission could last longer than the sponsor's protection permission. Under the new amendment, where the sponsor has a 30-month protection grant, the partner's permission will normally end on the same date as the sponsor's leave. This helps keep both permissions aligned. Another important clarification concerns children joining relatives in the UK. The updated rules now make it clearer that decision makers must consider whether there is a parent or another family member who could reasonably care for or support the child. The statement also updates the child route under Appendix FM. Applicants will now need to show that suitable arrangements for the child's care and accommodation are in place and comply with UK law. It's worth pointing out that these amendments do not fundamentally change family migration policy. Their purpose is to make the rules clearer and more consistent across different immigration routes. So those are the biggest changes covered in Part 1 of HC 259. The graduate route now includes a clear pathway for certain UK-born children, and several family route amendments have been introduced to improve consistency across the immigration rules. But that's only part of the story. In Part 2, we'll look at changes to the asylum process, new ETA criminality rules, immigration bail amendments, EU settlement scheme updates, scale-up route changes, and several other technical amendments that could affect future applicants. Thanks for watching, and I'll see you in Part 2.